Welcome to the Business SOS podcast. This is Rich Sierra, president of the Florida Small Business Legal Center. This is episode 150th of the podcast. Thank you for listening, supporting me for the last 2.5 years as we continue our quest to episode 200. Very excited about that. So last week we were talking about what to do or the first 48 hours after you get served with the lawsuit. So I want to make a quick point on that I failed to mention last time. And this is happening very often when people say, I just cannot afford an attorney, or attorneys are too expensive. And that's the reason people do it themselves or go to ChatGPT or go to AI because there's a tremendous gap in legal services for those who can afford legal services, especially business owners, and those who can't. However, there are a couple of things that you can do. At the very minimum, if you get served with a lawsuit, pay for that 1 hour consultation with an attorney to give you legal options. And at the very least, have a better understanding of what the options are, even if they're not good options, at least understand what they are. And there are always options available. Number two, there are attorneys that work sometimes on a flat fee basis, depending on the type of case. I know we do on occasions work on a flat fee basis based on stages of litigation, but attorneys can do that. You can talk to them, well, can you try to resolve this matter for X number of dollars? Can we get to a mediation conference for X number of dollars and see what the attorney can do? And in fact, most business disputes get resolved at through negotiation or at the mediation stage. Very small percentage, and I want to say maybe 1% of those cases actually go to trial. So your case most likely will get resolved throughout the process through some type of negotiation before it actually goes to trial. So in that case, see if it can be resolved sooner rather than later. And I'm a big proponent of mediation, as you have heard me before, because I'd rather get the problem resolved at the beginning stage of the process versus at the end when there's a lot of money invested in the case and the parties at that point say, I must well see what happens because I invested all this money. I must well take my shot at the court. So that is understandable. Having said that, there are cases that actually should go to court trial because the parties are not willing to settle, and the aggrieved party may not get relief only if it doesn't go to a jury or a court, a trial to a judge. So every case is different, but my point is that understand your options. Don't think that things are hopeless. If you get a lawsuit that you cannot talk to an attorney, you can. You might not, the attorney may not represent you if the funds are not available for his services or her services, but at the very least you have perhaps a outline of what your options are, and then you can decide how to pursue them. Also, the local bars have referral services for attorneys as well, and called the Broward Bar Association, the Palm Beach County Bar Association, for example, even Miami-Dade. They have a list of attorneys that sometimes work on a reduced fee or a flat fee basis. They can give you a referral as well. And in some cases, also, you have legal aid as well. I know they have one in Miami-Dade, Palm Beach, and Broward County. These are the areas that I practice for the most part, and also Orlando, that they have, some of them have business services as well. So it's worth giving them a call to see whether you would qualify for any type of assistance of through legal aid. So those are the three. I wanted to at least share that with you. So to prevent you or to discourage you, I'm not going to prevent you from doing anything, but certainly to discourage you from trying to handle things yourself in a lawsuit, if you'll be able to get some type of legal advice. So I just wanted to share that with you as well. So let's talk about today's topic. This is episode 150 of the Business SOS podcast. So I want to talk to you about the topic is demand letters that actually work. And I get often calls say, I want a letter to be sent out. Somebody has not paid me money. How much will it cost me to get a letter from your office? And, the answer is always, it depends. Um, the situation with demand letters, they they have a components to them. Demand letters have, especially coming from a law firm, right in there, it just raises the threshold of the controversy when a law firm is involved. So in this case, I'm going to focus on you sending the letter with an attorney, but I'll tell you so that before it escalates to a law firm versus law firm type of interaction, it's you sending the opposing side a demand letter and saying, okay, this is what I need from you. This is what happened. This is why I believe I'm owed this money, for example. This is the reason why. This is the contract, the invoices. This is the consequences if you don't comply within X number of days. And that's kind of the anatomy of a demand letter. In our case, we say we represent X, Y, and C client, and our client has retained us to collect the amount of X number of dollars. And based on the terms of the contract, we spelled out the terms. You owed, say, $100,000 for sake of argument. Attached to the invoices that we have that have been submitted but unpaid. This is the service that we provided, and he attached a copy of the contract as well. And if we don't get a response within, say, 10 days, we have been authorized without further notice to file this lawsuit. Just kind of give you kind of an idea what a demand letter will look like. A lot of times, demand letters are ignored. The reality is that there's no obligation from the recipient of a demand letter to do anything. It's simply what is called pre-suit communication. It's before the lawsuit. So, but there's not an obligation. It's a good idea not to ignore the letter. And if you have heard me before, if you're the recipient of a demand letter, my suggestion is not to ignore it because you have an opportunity to resolve whatever that demand letter is stating before a lawsuit is filed. And that's a lot better than after the lawsuit is filed, and less expensive as well. But not everybody acts upon demand letters. So say you want to, somebody owes you money, you want to write a demand letter. It's important when you write a demand letter not to make it emotional, not to make it personal. And if you're writing to a former client, or and I say former client because the client owes you money, most likely to be a former client, will not be a current client because you don't want to keep providing services if you're not getting paid. Don't make personal attacks in that letter. I mentioned that before because if you have that communication will not be protected communication with respect to any type of immunity. It's not a judicial proceeding. So you don't want to put anything derogatory or defamatory in any type of letter or disparaging. Just stick to the facts. And there's some cases that you might have a notice provision in your contract to the demand letter. So, for example, if there's a reason that the contract states that you have to provide notice, a written notice to cure, whether it's an invoice or a breach of contract, and provide a 15-day cure provision, then it's a prerequisite for you to do so. You don't have to do that letter to an attorney. You can do it yourself, but do it correctly. The tone of the letter has to be professional, firm, and calm. Not without any type of threats, personal threats for sure not, or threats of criminal prosecution, or no, just stick to the facts. It's a civil matter, so it's a civil dispute. you want to be focused on those facts and also not being hostile. Because that letter very likely is going to be read by the attorney who they may hire, or it could actually be in a court document. So when you are writing a letter, and I remember when I graduated from law school in 2004, we went to our ceremony to be sworn in. One of the judges, I remember this was yesterday, in terms of they have people giving us advice, which we are new lawyers, so obviously we want advice and uh, we need advice. So he said, write to opposing counsel the way you would write to a judge. And if you do that, you'll never get in trouble. And I followed that. I followed that advice and has served me well. Because whatever I write could be used, could end up in a pleading. It could be in a lawsuit, could be a part of a discovery. So I want to make sure that whatever I write to the opposing side is something that the judge will read and will not be offended by it. So the same advice I give to you. When you write something, or you write a demand letter to the other side, to the former client, or to a vendor that perhaps did not do his or her job, write it in a way that that if it's read in a court document, it's including a court document, it is okay to include it. You might have to go through some drafts, and that's fine. Drafts, I go sometimes through 5 or 6 drafts before something goes out. So it's okay to draft it, then you clean it up, draft it, clean it up, and then you can perhaps send it out. If you have a letterhead, use the letterhead. I think it's important. It shows formality to do that. If you send it via email, it's okay. Just make sure you do it with return receipt and delivery confirmation from the email, but also it's good to send it out certified mail return receipt requested. So that way you have confirmation of the receipt, especially if it is something that is required by a contract or required by the statute. And I'll go over some of the statutes that I know have a provision that you need a pre-suit letter. But those I recommend, the ones that I'm going to talk about, recommend you have an attorney do it, not you. Because there's specific criteria that we gotta have. If it's defective, then it may not work. Now, the question is, should you do this yourself or should you have an attorney do it? My suggestion, if it's a few $1,000s, perhaps anything less than $10,000, maybe you can send it yourself because you're in small claims territory. If you're dealing with a dispute that is in the $50,000, $60,000, $100,000, there maybe an attorney should write it for you because that's a higher dispute. So it's kind of a judgment call there. There's no rule that a specific amount has to be written by an attorney. It's up to you, what you feel comfortable with. My rule regarding issuing threats with letters, and the reason I don't do demand letters unless I'm retained with the purpose of seeking the litigation, because I don't like to issue threats that I'm not going to follow through on. So it is important that if I do a demand letter for a client and I state there that this firm has been authorized without further notice to initiate legal action against you for X, Y, and Z, that I already have the authorization to do so, and that I will be able to follow through if my demands are not met. Likewise, if you're going to write a demand letter, don't issue threats you're not willing to not follow through with. A way you can phrase that without being so specific is that if I don't receive response within 10 days or I don't receive the check within 10 days, I will continue the process with any and all legal options available to me. That's very broad, not specific. You're not getting in trouble for that. And you can decide what the legal options are. Excuse me a second. When you write the letter, it's important to tell your story in a factual and concise way. And you can look at the outline. First, you will do an outline and say, okay, this letter is in reference to the amount, the outstanding balance of X, Y, and Z, based on services rendered between this time and this time, on invoice numbers, the invoice numbers. Then, if you have a contract, set pursuant to a contract, you agree to pay the invoices within 30 days, as invoices are past due within 90 days. And we have attempted made several attempts to contact you to try to get this matter resolved amicably. Unfortunately, has not been the case. Has forced us to write this final demand for payment for the amount that is owed. If the amount is not received within 10 days from the receipt of this letter, we'll pursue any and all legal actions available to us. So you have kind of the gist of the letter. You send it out certified mail, and if they don't respond, then you have two options: do nothing, or get an attorney to help you take it to the next level. If it's small claims, you do not need an attorney to pursue it. You can do that yourself, and many courthouses have self-help sections. Some of them are online, some of them you got to go to the courthouse. But the small claims process is designed to make it simpler for you to be able to pursue it. So in Florida, if it's an amount less than $15,000, then you can pursue small claims. If it's anything above that, then it's going to be you're dealing with county court, but at that point, you need a lawyer to pursue it. Now, what happens when they contact you? Okay. A couple of things can happen. If you're negotiating directly with the business owner, you can negotiate an amount. But it's important that if you agree to something, to agree to a lesser amount, to put it in writing and get the person to sign. That could be in form of settlement agreement or memorandum of understanding or an agreed term that you agree to do that. Okay. I don't like when people make agreements via text messages, because then you're dealing with an issue of context that the text messages are not understood, and also more difficult to deal with that in the case of a dispute. So yes, you can send an email stating, okay, just pursuant to a conversation, you agree to send the amount of, say, $85,000 from the outstanding balance of $100,000. If this amount is received by X date, then we will consider the matter completely resolved. So, and then that person acknowledge that email and say agreed. That in itself is binding. You have offer, acceptance, consideration. Everybody accepted that. Okay. So that there you have an agreement to settle. But it's important to get any type of agreements in writing. Now, you might have a situation the other side may send you nasty text messages, nasty emails, or angry emails. So do not engage on that type of communication. If it looks that things will escalate and it's not going to get resolved, at that point, you have to get an attorney to help you resolve the matter. Because if you try it amicably first, it did not get resolved, you send a demand letter, didn't get resolved, it's just not going to get resolved without any type of an attorney getting involved. So at that point, you know the answer. You try to get a graceful exit for the person to comply with your demands to pay you. And the person chose not to do it. At that point, then you get an attorney, and the attorney will take it from there and may decide to send the demand letter or to file the lawsuit. Now, what happens if it's an attorney that contacts you? Say you send the demand letter, but it's an attorney who contacts you to try to settle. Okay, in that case, my recommendation is to get an attorney to represent you to deal with the other person's attorney. Don't try to do it directly with an attorney. Number one, they do this every day. We do this every single day. We train professionals. You don't. Number two, the proposed settlement agreement that the attorney may draft, it might be more leaning towards his client than you. In fact, it will be leaning towards his client protection. So just because an attorney sends you a settlement agreement, the attorney is not representing you, representing his client, the potential defendant. So you need to have an attorney on your side looking at the settlement agreement to protect your interest. So there are a couple of attorney triggers here, as you see the theme of my podcast throughout, basically, not only today, but prior podcasts. There are times that you need to get an attorney, and especially if there's an attorney on the other side that is handling the dispute, negotiating it with you. And you might get an attorney to help you finalize the settlement. So that is important. There are a couple of things I don't like that should not be used in a demand letter. It's never a good idea to threaten criminal prosecution and someone paying a civil debt. It's just not. It's not recommended to do that. So if there's any type of issue that you feel that the matter should be prosecuted for potential crime, my recommendation is contact the police department or the local state attorney's office for them to do the proper analysis on whether or not the dispute that you have with this other side is something that rises to a level of criminality. But it's not a good idea to threaten criminal prosecution on a demand letter, especially for a civil matter. Do not threaten to ruin the reputation or going to the media. It's just not something that I would recommend. Don't make disparaging remarks because you will end up in a potential defamation claim. Then you might end up being the defendant in this case. Don't list like a list of consequences that the person would have if the person does not pay. I think just stating that you will pursue any legal remedies that is sufficient to tell the other person, hey, you know what, this might escalate if this matter does not get resolved. But it's not that specific enough that people say you're going to take any type of action. And again, I don't like making demand letters threatening actions that I'm not authorized to or not the client's not willing to do. So the demand letter has to, if it's going to be, we're going to pursue legal action, the client already has to say, yes, we will pursue legal action if they don't pay. So that way the threat carries weight. It's not an empty threat. Don't threaten, don't use language. If you don't pay, you're going to regret this, or you have no idea what is coming. Don't say that in the demand letter, certainly not in the demand letter, but don't send that via text or email. Remember, all this information, all this communication that is written at some point might end up in a court document for everybody to read. And in fact, opposing counsel is going to be using that email and cross-examining that email. What do you mean about you don't know what's coming? What exactly was coming? So we can have 10 or 15 questions out of that alone. So just to throw you off and just to kind of push the button. So don't threaten to ruin your reputation for sure. That could be damaging to you as well. A couple of letters that has to be sent pursuant to a statute. And I'm going to mention two. There might be other ones, but I'm going to mention two. When you have any type of, construction defect, that's Florida Statute 558. Say somebody, you have a kitchen remodel in your house, and then for whatever reason, the contractor stopped working in your project, and then you don't have the project has to be completed. In Florida, you have tried the phone calls, you have tried everything, nothing has worked. So before you sue the contractor in Florida, you have to send a written notice of at least 60 days before filing a lawsuit for them to complete the work. Does Florida law? You have to go to a pre-suit letter. So that's one of them. If you are in a situation that you have to send a pre-suit letter, my recommendation is to get an attorney to do it for you. Don't write this pre-suit letter yourself. The other one is civil theft. Civil theft, Chapter 772, Florida statutes. You have to send a written demand at least 30 days before filing the lawsuit. Civil theft seeks triple damages for the amount that you're disputing, that you're owed. And that's a higher standard. And I can do another podcast on the civil theft statute. It's going kind of on a deep rabbit hole here. But the point is that if you're in a situation that you have a statutory letter, this is different from demand letter. Demand letter is like, you owe me money, I'm going to send you this. This is the final warning before I file a lawsuit. Okay. This is statutory letters that you have to do before taking any type of legal action. At that point, you need to have an attorney do it simply because if their letters are defective, and unless you know what to do here, if the letter is defective, it's like you never sent it. And that entire claim can be gone. So don't think that you're helping the lawyer, but I'm going to save some money by sending this letter myself. And then I'll let him know, hey, 30 days have lapsed, file the lawsuit. Because the attorney will look at the letter and say, well, this letter is defective for whatever reason. Then you have a situation that the letter has to go out again, and you wasted 60 days. So I want to at least share that with you. Statutory letters have attorneys do it. If you send a letter, kind of wrapping this up, you send a certified mail return receipt requested, or send it via FedEx or UPS, a place you can track the delivery of the letter, because that will be important later on when you're trying to show that the demand letter was sent. Obviously, keep a copy of everything. If the deadline passes and they have not responded to whatever demands you seek, then you have to seek legal counsel to help you pursue that further. And the only two options here, either you forget about it, don't do anything about it, or you do something about it, and you can do it yourself. It's not advisable, but if you have a company, a corporation, or LLC, you cannot do legal proceedings by yourself. You need to have an attorney to do it. So in that case, my recommendation is to get legal counsel to help you advance the matter forward. You also don't want to wait too long. There's statute of limitations for different cases, causes of action. For contracts, it's 5 years in Florida. For most other, offenses or claims, not called offenses or torts, is 4 years. Your attorney will tell you what a statute of limitation, is like. It is. I think this is good for today. Just going to wrap this up, just give you an idea in terms of the demand letters. Demand letters are helpful because it tells you the side that you're serious about your claim, and that if it's not followed, if they ignore it, you will pursue legal action. It's an opportunity to resolve the matter before a lawsuit is filed. Again, you lay out the facts. Don't vent in the letter. Don't threaten. Don't disparage. Just stay focused on the facts and ask specifically why you're seeking, and also put a deadline to that, a date. Send it via FedEx or certified mail, where you can track it. And of course, if they ignore the letter, or they don't pay, they don't negotiate a settlement, then at that point, seek an attorney and follow through with your demand, with your threat, which is to pursue legal action and move forward. If you have any questions about what we talked about today, my email is rich@richsierra.com. My phone number is 866-842-5202. My website is floridasmallbusinesslegalcenter.com. If you want to see this video via YouTube, the channel is youtube.com//@RichardSierra. Um, Remember my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. Until next week, this is Rich Sierra, and my goal is to help you succeed.